It's official. The moment we've been waiting on. The Department of Justice has filed their case against Georgia Tech University, and it details all of the findings from their investigation. Woo! And let me tell you, the DOJ, when they investigate, apparently they leave no stone unturned. Let me tell you, when the Department of Justice shows up at your door and you're under oath, sworn testimony, everybody starts singing. This is not like the mob or gangs where there's allegiance and people are willing to die or go to prison to withhold the truth. No, this is cybersecurity, it's IT, and people are not going to put their careers on the line to fabricate stories. They're going to tell it how it is when they're under oath. In this video, I'm just going to highlight just some key takeaways from the 99-page case filing. Me being a compliance geek, I've spent the last 2.5 hours reading it. Took me a little longer because whenever I'm reading these cases, I take extensive notes so that I can summarize it, synthesize all that information for you all. You're welcome. However, I will share a link to the case if you want to read it for yourself. But I'm going to give you the key, the highlights, the meat and potatoes, what you need to know. In my previous video, you can find a link to it above. I covered in detail the original False Claims Act claim that was filed by the relators. Those are those whistleblowers. One was a previous Georgia Tech employee. Another one is a current Georgia Tech employee. And that one detailed their findings, their allegations of the non-compliance with the Department of Defense contractual clauses, DFAR 7012, DFAR 7019. In that video, I go into detail about all of their allegations, their accounts. But in this DOJ case, it goes into a lot more details related to the specifics of the findings from their investigation. It is very thorough. I'm not an attorney, but from a layman's perspective and a certified CMMC assessor's perspective, the DOJ has a rock solid case. They have extensive evidence, witness testimony under oath. They have the contracts that were signed that included all of the DFAR's clauses. I won't keep you waiting any longer. Let's get into it. Just to recap some backstory, the original case was brought by the whistleblowers, also known as the relators, on behalf of the government. And then once that case is brought on behalf of the government by the whistleblowers, they have the option to attach themselves to the case and essentially take first chair and lead the civil case against Georgia Tech. Well, the Department of Justice did decide to attach themselves to this case. They decided to intervene and lead the civil suit. So that's why they had to file their case, which is now public and what we're going to discuss now. Ultimately, the DOJ's case focuses on two Department of Defense contracts. One is an Air Force contract and another one is a DARPA contract, both which includes the handling of controlled unclassified information, also controlled technical information. Essentially, the lab in question for this case is the Astro Lavos lab, and the principal investigator for the Astro Lavos lab is Dr. Anto Nikakis. Hopefully I'm pronouncing that correctly. That is the scope of the Department of Justice case for this False Claims Act. Okay, so let's take a look at some of the key factual allegations. I intentionally have the word factual allegations in quotation marks because this case has not been decided yet. The Department of Justice, on behalf of the United States government, is requesting a jury trial. Based on the evidence outlined in this case, I would imagine that Georgia Tech is going to be highly motivated to settle this case. However, that's to be determined. But within the actual case filing, there's a section called factual allegations. Again, I'm not an attorney, but I'm imagining that these allegations are factual in nature. They have been substantiated through evidence and sworn witness testimony, so I guess they cannot be refuted. But certainly if you're an attorney and you have a better description of what the factual allegations mean in the context of this case, please let me know in the comments. The Astro Lavos lab failed to install, update, and run antivirus or incident detection software on those in-scope endpoints, the endpoints that are within that lab that process, store, transmit any of that controlled unclassified information or controlled technical information that was received or and produced for the Air Force contract and the DARPA contract. So those contracts do include the FAR 7012 clause, which requires defense contractors to implement all of the NIST SB 800-171 requirements. All in antivirus, that's one of those requirements. According to the DOJ, the Astrolabos lab did not have a system security plan, which is another requirement that's part of the NIST SB 800-171 requirements. You have to have a system security plan. All roads lead back to that system security plan, which is essentially the compliance story. It details how the defense contractor is satisfying the requirements that they have as part of DFAR 7012. Let's see, it didn't have antivirus installed on the in-scope endpoints. It didn't have a system security plan. And number 3, saying that they knowingly and or negligently provided a false summary level score, so a SPRS score, prior to being awarded a contract. Part of that award requirement is the defense contractor has to submit a SPRS score per DFAR 7019. So essentially, a SPRS score is allotting 1 point for each of the 110 NIST SB 800-171 requirements. So the max SPRS score you can have is a 110. The lowest SPRS score you can have is a negative 203. As outlined in a case, apparently Georgia Tech submitted a SPRS score of 98. That's 98 out of 110. However, as the case details, that score was not factual. It was knowingly inaccurate, and it was based on a fictitious network, or a network that really didn't exist and wasn't accurate to the network that was used for the Astrolabos lab. That's a major infraction, non-compliance. It's kind of hard to defend against that accusation. Number 4, the defendants knew the federal cybersecurity rules. So that keyword in law is knowingly. Can't use as defense ignorance of the law or ignorance of the contractual requirements. This case outlines substantial evidence in addition to sworn witness testimony about the Georgia Tech senior leadership, the principal investigator. Everyone involved knew of the requirements, knew that CUI and CTI were in scope. However, they still failed to comply with those requirements, whether it was due to being overly burdensome, inconvenient, just didn't want to do it. Who knows? I can't speak to that. But the DOJ is saying they clearly knew that they were violating their contractual requirements. That's why it's so important to understand what those clauses are in your contract, especially if you're doing business as a federal contractor, in this case, a defense contractor. There are a lot of cybersecurity requirements that you have from a contractual standpoint where you're obligated to comply with those requirements. It's not optional. You really need to understand those requirements, because when the DOJ comes knocking, you can't say, oh, I didn't know. That's not going to fly. Then number 5, the defendants knowingly violated the federal cybersecurity requirements because they wanted to retain those lucrative contracts. So if you watch my first video that details the whistleblower claims, Georgia Tech has over $1 billion in federal contracts. So they're a big player, especially in the defense space, as a prime contractor and also a subcontractor for Lockheed Martin. It's a lot at stakes. It is kind of surprising that cybersecurity, if these allegations are substantiated and proven in the court of law, that Georgia Tech senior leadership did not take cybersecurity more seriously, or non-compliance with their contracts. That's all to be determined by a jury. If it gets that far, I highly doubt it goes to a jury, because again, this is not looking good for Georgia Tech. I just don't see what defense they could have, especially once the government gets involved, where it's pretty hard to fight the United States government. They've done extensive research, and they have the power of that sworn testimony. It can get ugly. If I was Georgia Tech, I wouldn't want to put this in front of a jury, but I could be wrong. We'll see. So this kind of highlights the top 5 factual allegations. I believe it may have been one or two more that I didn't add on this list. However, they all kind of fall under this umbrella of just knowingly not complying with those contractual cybersecurity requirements. Remember the DFAR 7012, the DFAR 7019. They also mentioned DFAR 7008. In the beginning of this case, they outline all of the contractual requirements, explicitly stating this is what you have to do as a defense contractor in order to qualify for this contract, in order to be able to submit invoices. So from that standpoint, government has a rock solid case. The key difference that I would say I noticed from the whistleblower's case and now the DOJ's case, this one's a lot more detailed. It goes into all of the contractual requirements. It painstakingly outlines all of the evidence, a lot of the sworn witness testimony from previous CISOs, from the director of the research, also from the principal investigator, Dr. Antonakis. It's a lot of just admission of, yes, we knew the requirements. Yes, we knew that we were handling controlled unclassified information and controlled technical information. In addition to that sworn testimony, the DOJ also has email evidence. They also have text message evidence. They have a lot of evidence. And I guess that's why in that section that I just pretty much showed you where it said the factual allegations, where all of those allegations are substantiated with facts. That is really tough to overcome. And then also what I found pretty interesting was in the section regarding damages, where the Department of Justice pretty much highlighted that ultimately Georgia Tech induced the government into awarding them contracts and also allowing them to retain contracts because they allegedly submitted a false SPRS score, which is taken into consideration as far as contract award. And every time they were submitting invoices to the government, it's considered false claims because whoever submitted that invoice on behalf of the defense contractors to certify that they are in compliance with all of the provisions of the contract. And those provisions include the cybersecurity requirements that we discussed, the DFAR 7012, the DFAR 7019, the DFAR 7008, long list of them. So for the two contracts that are in scope for this case, the DOJ says there is a total of 14 invoices totaling millions of dollars. It shows invoices on the invoice when submitting it. There's an explicit certification of compliance with the contract. From the government standpoint, they said this defense contractor is not eligible to submit invoices because they're in violation of the contract. As was highlighted in the original false claims case, in this DOJ case, they did highlight also there was a point where one of the senior leaders that was over research stopped invoicing the government on one of the contracts because once she was informed about the antivirus not being installed on the laptops and systems in that lab, she realized that this could be considered a false claim because they're not in compliance with the contract and they can't invoice the government. Essentially, the government is saying these false claims go back to the beginning of the contract. If you were not in compliance, as DFAR 7012 outlines, no later than December 2017, those invoices to the government for payment and explicit certification of compliance is false. It's fraud in the government's eyes. The government explicitly stated in the case that Georgia Tech was not entitled to the money that was paid by the government. This all is outlined towards the end of the case in the damages section. And if you recall, with these whistleblower cases, the government is entitled to treble damages, which means 3 times the damages that they have outlined. In this case, we have millions of dollars worth of damages. At a minimum, they're saying that those 14 invoices are going to represent the damages, which is millions of dollars. Now it's treble that 3 times whatever that amount is, plus the legal costs. We're talking a lot of money. Even in the settlement, I can imagine it's going to be multi-millions of dollars. But if it goes to a jury trial and the jury finds in favor of the plaintiffs, which is the United States government, and also the relators or the whistleblowers, then it could be a lot more. I don't think Georgia Tech's going to take that chance, but I don't know. Again, I'm just a layman. Another thing that was highlighted in this case is the government kind of reoccurring theme. going back to the allegations with the false SPRS score and also the inaccurate or misleading SSP, the system security plan, knowingly non-compliance with those cybersecurity requirements is material to the contract, to the government, essentially presenting false or material claims for payment. Those millions of dollars were paid under false pretenses, which my interpretation of that, essentially, the government is entitled to recoup all of that money. Yikes, times 3. That is a lot of money. Well, at least a lot of money for me. But maybe for Georgia Tech, that's a drop in the bucket. Who knows? We have over $1 billion in government contracts. Just to reiterate that, and I quote, compliance with federal cybersecurity requirements is material to the United States contracting and payment decisions on DOD contracts. That's a direct quote from the case. Stated the Department of Justice attorneys that are trying this case. This certainly should be a notice to other defense contractors that compliance, 100% compliance with those cybersecurity requirements, which is what you have to do under DFAR 7012. It's 100% compliance unless you have exception approved by the DOD CIO, the Chief Information Officer. That has to be in writing. I haven't heard anyone getting any exception to any of the requirements in this SB 80171. Towards the end of the case, in addition to the damages, they talk about the primary motivation for the non-compliance. In this case, they're saying it was financial gain. Georgia Tech wanted to get awarded and retain lucrative contracts, which is the case in a lot of fraud cases where money, it can blind you. Not saying that's what happened here, but just generally speaking, when it comes to fraud, it's greed, it's money. I do want to highlight that as a candidate, C3PO Aspire Cyber has had to implement all 110 NIST SB 800-171 requirements. And let me tell you, it is not easy. It's hard. It's expensive. There's a lot of documentation requirements in addition to technical and administrative requirements. So I don't say for 1 minute that this is easy. It's part of doing business. If you're going to do business with the federal government, especially Department of Defense, you just have to know this is part of it. And the stakes are high because, as outlined in this case, national security is at stake. Our adversaries are targeting defense contractors, trying to steal our nation's secrets, Department of Defense Intelligence, CUI, CTI, to help accelerate their research and development, weapon systems. So it's understandable why the Department of Defense is taking this so serious and expecting their defense contractors to adhere to the cybersecurity requirements. That summarizes the key takeaways from the case. I'm going to share the link to the case if you want to read it for yourself. 99 pages of pure bliss and joy. For me as a compliance geek, it is like reading a romance novel. Once I picked it up, once I started reading, I couldn't put it down until I finished. Hopefully you got something out of this synopsis, the down and dirty. If you are a defense contractor, you're looking for help trying to navigate through these cybersecurity requirements. I know they're complicated. I know they're very confusing. Hey, you have help. Certainly reach out to Aspire Cyber. I'm a certified CMMC assessor and a CMMC provisional instructor. I eat, live, breathe CMMC, help several clients navigate the cybersecurity requirements and accelerate their compliance activities. That is what we specialize in. Don't hesitate to reach out to us if you have questions. Happy to help, happy to answer any of your questions. And also let me know what you think about this video. Spend a lot of time trying to put out content to just educate, knowledge share. Hope you get some value for it. Be sure to subscribe. Helps us this channel out a lot. Give us a thumbs up. Till next time, stay safe and do the right thing.